Good afternoon, everyone. My name is Dave Kubikian, and I'm one of the attorneys here at the Herzog Law Firm. It's Friday, which means it's the conclusion of our webinar week. We got through another one here, folks. The topic today is estate planning for young families. It's one of the most actually important topics we will ever cover because young families are specifically the demographic that fails to have wills the most. They fail to have plans the most. Why? Because we're young. We're young. Well, we're not young. I can't say we because I'm no longer young, but you may be young, or your kids may be young, and you're worried about planning for your grandkids. It's a shortish topic. It's going to cover a lot of the basics, but the basics are so darn important when we have small children, as you will see. So let's get into it. When's the right time to create your estate plan? Well, there's never a wrong time. So I object to the form of the question to begin with. But certainly when we're 18 and older, it's terribly important to have at least a really super basic estate plan. I'm talking healthcare proxies. I'm talking powers of attorney, because after all, at 18, you are an adult, right? Certainly if you're married in a relationship, and even more so, I have so many friends who are actually not married, but they're like they're married. They fight like they're married. They've been together forever. And they actually need a plan more than married couples, because if you're not married, you're not married. And there are certain rules, as you'll see, that apply to married couples or just friends or non-married couples as well. Certainly, if you have minor children, it's imperative that you have a will, if nothing else, because your most valuable asset is 3 years old. And we want to make sure that that 3-year-old has guardians named for them. Every now and then we'll hear of a client whose child is in their freshman year of college, and lo and behold, they get into some trouble, or their health is not so good for they get sick, they have to go to the hospital. And our clients learn really quickly that at 18, your children are adults and you're no longer able to access records or see their grades and so on. And so, just being 18 or over makes it incredibly important that you have those advanced directives. Again, we're going to spend some time getting in depth about those different directives later on. One of the things about law, specifically this area law, is that sometimes the reason you do things are because of what happens if you didn't do those things. And what I'm talking about is something like a guardianship. If you get into a car accident, God forbid, and your brain becomes mush, that's going to happen regardless of whether you had a power of attorney in place or not. But the fact that you do have a power of attorney in place means that we don't need to have a guardianship done for you. We don't need to go to court to have someone legally appointed to handle your affairs. Doesn't seem like a big deal. It's kind of like a $15,000 big deal, sometimes $20,000 big deal, just to get to the same place that the power of attorney would have. However, with the power of attorney, again, we'll have a couple slides on it later on, we're not giving up any powers. You just give someone else the power to also do things, as opposed to a court getting involved and deciding who is going to now take powers from you, which is something we'd like to avoid. If you're married or in a relationship, the stakes become obviously a little higher. The reason why is because if you die without a will in New York, depending on whether we have kids, so if we die in New York and we are married without kids, everything goes to our spouse, or at least everything that's in our estate. When we are married with kids and we die without a will, that same estate is actually divided about $50,000 to our spouse, and then 1/2 of the remaining assets goes to them. The other half goes to the kids, and it doesn't matter if they're 3 years old, or they're 10 years old, or they're 12 years old, or they're 18 years old, which is sometimes more problematic than being a minor. One of the downfalls of that is that I want, if you're a young family, by definition, you're young. And if God forbid something happened to you, your spouse is likely around for a really long time. And I don't want them sharing money with your kids. They need maybe all of your dollars to help raise that family of yours. Okay. So incredibly important. Now, you heard me say spouse, because if you die in New York and you do not have a spouse, and you don't have kids, everything actually goes up to your parents. No parents over to your siblings, then to your nephews and nieces, then to grandma, grandpa, uncles, aunts, first cousins, and so on and so forth. What you didn't hear there is life partner, the woman or the man that I love for decades, right? The person I've lived with, the person who basically is my significant other, they are my spouse, except not that word. That word doesn't apply to them because we're not married. So that relationship part becomes so darn important. Oh, this is like a slide. This could be a whole presentation on its own. So I have two little kids. I have a 3-year-old and an 8-year-old. Okay. And I have a wife, and she is my beneficiary on my life insurance. And I ask people all the time, who do you think is the backup on my life insurance? And they say, my kids. And that's where I have to point out that they're actually quite crazy, because didn't you listen? I told you they're 3 and they're 8 years old. The reason for having an estate plan, whether it's a will, whether it's a trust, whether it's a little less, a little more, okay? The idea is that I need rules on my money. When it comes to minor children, it is not enough to say I leave them money. I got to get more in depth. I need rules on that money. I got to make sure they don't decide not to go to college because they think they have a lot of money. I got to make sure that they get money in steps. I got to make sure that their school is going to be covered. I got to make sure that they're going to have a good life, even though I'm not there for them, right? And likely neither is my wife, because minor children are getting money. I have to make sure I'm naming guardians for them, the right people to be, the legal guardian until 18 years old. I got to make sure we have the right people in charge of the money for them, a trustee of that money. My wife and I may fight. It's going to be her mom. It's going to be my mom. It's going to be my brother. It's going to be her brother, right? You got to work these things out. Otherwise, there might be a contested guardianship for your kids. And if it's not bad enough that they lost mom and dad, now they have grandma and grandma fighting each other and trying to move them all across the country, perhaps, all because you didn't have a plan. Whether it's a will, whether it's a trust, we can have pages and pages of language as to who gets what, when do they get it, how do they get it. You filled out life insurance policies before, and if you haven't, I have a great guy for you, okay? But it's a name and a percentage. That's all you end up filling out on life insurance, and that's just not enough, because where's all the pages and pages of rules? Where's nothing until a little bit at 22, a little more at 25, balance at 30 years old, right? That's nowhere to be found on beneficiary designations. And that's why it becomes so important that if you are a young parent, if you are a young grandparent and your kids are young parents, that you make sure that these basics are in place. Chances are, statistically speaking, nothing bad's going to happen, and certainly we're not going to pass away, right? Those are the odds. But if it happened, the worst thing that could possibly happen on top of that is your kids getting money, blowing through that money, deciding not to go to school, having an awful life because you didn't plan ahead of time. Okay. Sorry to get so down on an otherwise beautiful day here. I apologize. It's a topic I can't help myself. The basics, if I said to you, listen, all you need is a basic estate plan, what I'm talking to you about is a will, a healthcare proxy, living will, which we'll talk about later, as well as a power of attorney. These are the basics. What's a will? Well, everyone needs to have a will, right? Yeah, everyone should have a will. A will is a document that says who gets your assets when you're no longer here. You name an executor in the will. The job of the executor is to do what the will says, give it here, do this, do that. It's not just any other document. You don't just e-sign it or anything like that. In New York, you got to sign it in front of witnesses. We need 2 disinterested witnesses. There's a whole probate process to getting a will admitted. A couple of checkpoints that the government wants to see, the courts want to see, were done. They want to make sure you knew what you were doing. You had your mental capacity when you signed your will. You didn't have a gun to your head. You weren't drunk, right? They want to make sure that everything's all right. If there is no will, it's called dying intestate. And that's where we go back to New York's rules as to who gets what without a will. We have a spouse and no kids. New York says those assets go to your spouse. We have kids and no spouse. New York says everything goes to your kids. No age restrictions, nothing. Everything goes to your kids, right? They're going to put Toys R Us back in business. Spouse and kids. Now it's almost a 50-50 split, 50,000 plus 1/2 to our spouse, the other half to our kids. Like I mentioned before, no spouse, no kids, parents, siblings, nephews and nieces, grandparents, uncles, aunts, cousins, and so on. The wrong people may be getting your money. You may have charitable inclinations. You may want to take care of your significant other who's not your spouse. You may have some lovely nephews and nieces that you want to help out. You may have desires to leave everything to your spouse. I don't know what everything's going to be. I want you to make sure that you have a will. So easy. Oh, here you go. I jumped the slide. So as you see here, here are some bullet points as to how money passes if we die without a will. We die intestate. In a will, there's a couple important people. I mentioned an executor before. There's obviously beneficiaries, those people who get money when you pass. When it comes to young families, more and more you'll see the term trustee involved in a will. Typically, it's not, right? Executors are to wills as trustees are to trusts. But when we have young kids, as I mentioned, my own kids, it's not uncommon to have a trust within your will, right? I give everything to my spouse. If my spouse doesn't survive me, I give everything to my kids as follows. That as follows part is essentially what we would call a testamentary trust. It's a trust that is in your last will and testament, thus testamentary trust. Great news. It could be as complicated as you want. It could save the day. It could have all the rules as to when my kids are going to get money. Bad news. It's in my will. My will has to go through a probate process in order for those words to mean anything. We might have time later to talk about a standalone trust that you can create now. Maybe you do a revocable trust. We take your house, we put it in, take some money, we put it in, have some life insurance, point it to the trust. So your life insurance beneficiary becomes your trust. And upon your death or the death of you and your spouse, we have a trust that already exists, that already has money, that has new life insurance money come in. And now that big pile of money will go based on exactly what your plan is. A guardian is an incredibly important part of the plan here. Again, when we have minors that's 17 years old or younger, we need a legal guardian of the person. We need a legal guardian of the property of that little person. To me, a guardian is not enough because that ends at 18. And I'm telling you right now, guys, 18 to 30, that's the danger zone. That's where a lot of good decisions, a lot of costly decisions can happen. When it comes to guardian, right, choose wisely. It's going to be my mom. It's going to be my dad. Are you kidding me? You're going to have your mom be guardian? Sometimes it's a fight. Sometimes it's not a fight. You, husband and wife, spouse and spouse, each have their own will. You can name your own list of guardians. Okay, it's survival of the fittest technically. Now, just because you name someone doesn't mean they're automatically going to be guardian, but they got your stamp of approval. It's going to matter to the courts. It's going to matter that you picked people, that when you had the choice of anyone in this whole world, you picked your best friend and his wife. That's going to matter, especially when grandma's not too happy about that. The things I want you to take into account: where does someone live, right? You may want someone who's close. Kids, you don't want to take them out of their school district. You don't want to take them out of their area code or zip code. We don't want them going across the country. Are those guardians financially able to take care of your kids? Are you going to have a lot of insurance that's going to help provide for the finances involved with a guardian? If we pick a couple, do we have a backup couple? If one of them if they divorce each other, if one of them passes away or is incapacitated, I wanted these two people, but I wanted them because they're a nice couple. I didn't want them because they're two single parents, right? So we can do anything you want with the language. Oftentimes people pick a couple and then a backup couple if either one of that first couple is unavailable or unwilling. Family is obviously a wonderful choice as well. Take all these into account. There's no right answers. There's no wrong answers when it comes to guardian. Talk about a deep bench. We could make as many backups as you want. You can change your will as frequently as you want. Your group of friends may change. Your parents may start to get older. Your siblings may become knuckleheads. Anything's possible. So whatever you pick, it's not always a one and done, right? I had a client earlier today. The last will that they had ever done was when their kids were little minors. They were 3 years and 5 years old. Now they're 35 and 33 or something like that. So a lot can change over time. You know what? When those kids were 16 and 14, I wonder if the guardian in that will was the right person. So you got to look at these you don't just do it, right? Every couple of years, you should look at it and make sure that the people you pick are still the people that you'd want to pick if you're doing it all over again. Well, you got a will. That's great, right? That's in case we die. That's important. Sometimes even more important are your advanced directives. What happens when we're still alive? How do we avoid these guardianships? How do we make sure people can speak for us, can sign for us, and follow the things we would have wanted if we were okay? Healthcare proxy, living will, power of attorney, and a disposition of remains form. Again, lovely things to talk about on a Friday afternoon, I know. Healthcare proxies, pretty standard fare here, guys. You're naming someone to be your proxy, someone to speak for you if you're unable to speak for yourself. Hopefully, well, if you are a young parent, you, by definition, have been in a hospital at some point, or maybe not by definition. I shouldn't have assumed that. If you do go to a hospital, though, you're going to fill out some forms, and some of those forms are going to say who the doctors and nurses can speak to if you're incapacitated. They may very well be giving you a healthcare proxy to fill out. So why do I need one right now? Well, in case we're wheeling you in case something awful happened on the road, we don't have time, you're unable, you're incapacitated, we have a baseline. We have somebody who you named when we knew things were okay. Maybe that person's out of town and you're with your brother when you go to the hospital, you do a form right there and then and there to say that your brother can speak on your behalf. That document has 2 witnesses to it. It's incredibly important. It's incredibly basic, like incredibly, incredibly basic. Living will, not so basic. Living will is for end of life care. And a lot of people think it's pulling plugs. I think it's don't plug me in. It's a little more of that. And the idea normally, or at least in our form, is that most of our clients say, look, if I'm incapacitated, if my brain is mush, if I also have an incurable or irreversible condition that's going to lead to my death within a short period of time, if that's what's going on, don't unnecessarily keep me going. Don't resuscitate me. Don't make my lungs move for me. Don't operate on me. Don't poke and prod me. All right. It's incurable. It's irreversible. Nothing's going to change what has been done. You're only delaying the dying process. And this is what I want, or this is what I don't want. Okay. The opposite of that is I'm curable. I am reversible. I got COVID and I'm on a ventilator, but that's curable. Cure me. Put me on that thing. Get me better. Okay. That's not living will territory. Excuse me. That's healthcare proxy territory. Living will, end of life, incurable, irreversible, or at least that's the way we do it at our firm. Power of attorney. Now we're talking. Power of attorney, I think, is the most important document that I do. And the reason why is because with a good power of attorney, a lot of other documents can be done by your agent. Your agent is someone you pick to be able to transact for you. What they can and can't do is up to you. You actually, in the form, can initial all the different powers you want them to have. Okay. It's an official document. It's going to be notarized. Your agents need to sign the power of attorney. Later on in life, I'm going to tell you why it's really important to allow your agents to gift to do long-term care planning for you, but you're a young family, right? So we'll focus on the basics, right? Handle my affairs, pay my bills, talk to my insurance company, transact for me, sell this, buy this. Basic power of attorney gets it done. Of course, we want backups for agents, backup agent, backup agent, backup agent. Disposition of remains. Oh boy. Sometimes people ask me whether or not in their will they should put how they want to be buried or what they want to have happen. And I tell them no, because by the time your will actually means something, by the time we go through that probate process, you're going to be pretty stinky. And, the ship may have sailed on some of the really important organ donation and things like that. There's actually a separate form where you can officially notify people, have this document witnessed saying what your plans are, what your wishes are. And that document should be followed. That document's in effect immediately. More importantly than that, though, I think a lot of it's just communication. Sometimes our clients are pre-planning or even prepaying their final expenses. talk to your loved ones. Make sure they know what you would have wanted. It's important. I think it's important, right? So just talk to them and make sure they know. So that way they don't have to guess about what mom or dad or what brother and sister wanted to do if, God forbid, something happened to them. How often should you review this basic plan? Well, I think we're like top 6, top 7 on your emergency call list. If really good things or really bad things happen, I want to know about it. If we have a new child, I want to know about it. If we have one less child, oh my God, God forbid. If we're going through divorces, if we're going through new marriages or officially getting married, if we are just partners, changes in who your agents are, changes in how you feel about your agents or your guardians. Those are all really important times. How complex your life gets, your career is blowing up. We have properties here and there. It becomes even more important to have all these different pieces governed by one set of rules and updating those rules. Sometimes it'll be time to elevate your basic plan from will, power of attorney, healthcare proxy to a trust, will, power of attorney, healthcare proxy, because there's too many ducks in a row and we just got to make sure everything's organized. And now it becomes even more important to want to avoid probate. Thanks for joining us, guys. We do offer free consults, so don't think that you need to know everything now and you can't ask any questions. Those are usually 1 hour long, by the way, so plenty of time for me to get to know you and then scare the bejesus out of you, and then maybe we come up with a good plan. We also have a radio program on Saturday mornings and Sunday mornings. Don't call on Sunday because it's a live program on Saturday. It's just a recording on Sunday. We have other webinars. They're all on demand. You can go to herzoglaw.com, www.herzoglaw.com, to check out any of our other webinars. And obviously, we'd love to have you take part in our future webinar weeks or just check in with us whenever. I really appreciate you guys taking some time on a Friday. I know it's pretty beautiful out, and we'll see you soon. Take care.